Welcome once again to Lehto's Law. Here's Steve Lehto.
I was a bit hesitant to do this story because one of the most viewed videos on my channel is about the idea of them asking to see your receipt as you exit a store. And a lot of people respond to that by saying, Steve, if they demand to see my receipt, I'm going to say, I didn't steal from you. Are you accusing me of stealing? And if they say yes, I'm going to sue them and win millions of dollars. So the headline of this story is going to make some of those people think that they were right, but they weren't. But we'll get into this. Out of Mobile, Alabama, from WKRG television. Woman wins $2.1 million from Walmart over false arrest. Now, there's more to the story than you might think, so just bear with me. A woman who says she was falsely accused of shoplifting at a Walmart store has successfully sued the country's biggest retailer for damages to the tune of $2.1 million given to her by a Mobile County Circuit Court jury in Alabama. The lawsuit was filed by an attorney back in 2018, and what they're talking about primarily is Walmart's practice of using a little-known state law to collect money from people accused of shoplifting from the retailer, even though some of those people may have been falsely accused. And you'll notice that the headline said arrest. Now we're talking about accusations. So the woman was not arrested as far as I can tell. Criminal charges against the woman were dismissed. The company, however, continued to send letters to her demanding $200 in settlement. And that's the law we're talking about. Many states have a law that says that if you run a business and someone steals from your business, you can go after them for civil damages, seeking to get them to reimburse you for what they stole from you. And depends on the state you're in. Some states don't require a conviction. And apparently, that's the issue here. An expert testified that Walmart and other major retailers routinely use the practice of the civil recovery in states where loosely written laws allow it. And depends on what state you're in as to how loosely written it is. Testimony revealed that Walmart made hundreds of millions of dollars from the practice in a 2-year period. Defense attorneys for Walmart argued that the practice is legal under Alabama law, and thus endeth the story. So from the facts that I just read to you, now, by the way, I've got more for you, but just the facts of this story, it appears that Walmart said to the woman, we think you stole from us. They got her information, and they may have even reported her to the police, but charges were dropped. She was never prosecuted for it. But they sent her a letter saying, you owe us $200, or if you don't pay us $200, we're going to come after you and sue you for it. And it may have been made and couched in terms of an offer to compromise, meaning that if you don't pay us $200, we're going to sue you for more than $200. And she says apparently that she got a few letters like that because they continued to send letters, plural. And so there's no mention in the story of an actual arrest, okay? There's only the mention of the accusation and then the demand letters. So I'm familiar with this because in Michigan, we have a parallel law, not identical, but parallel. And I've known people who've owned businesses, and I've talked to them about this. A friend of mine owned a gas station, and he'd have people pull up, get gas, and drive off. And he would chase after those people, figuratively and literally. So MCL 600.2953, from the blue books behind me, retail fraud, liability, and civil damages. And civil damages are distinguished from criminal. So civil, criminal. Criminal is when you're charged with a crime, and the state is who's opposing you, or the people of the state. And civil is where you're being sued, and you can be getting sued by anybody. The state can come after you, believe it or not, for civil damages, so can the Fed. But it's often an individual or an entity that is not the state itself. So demand for payment, non-compliance, effective payment, civil action, et cetera, et cetera. So in addition to applicable penal sanctions, a person who commits an act for which he or she could be charged with retail fraud is liable to the merchant who is the victim of the act for the full retail price of unrecovered property or recovered property that is not in saleable condition, and civil damages of 10 times the retail price of the property, not less than 50, not more than 200. So the way this is written, it says if you commit an act for which you could be charged, and it doesn't say for which you have been charged, it's for which you could be charged. So if a shoplifter gets caught in the act of shoplifting, even if the people, the state, the prosecutor, whoever doesn't want to pursue it criminally, the merchant here can still go after the person. There is a question of whether they recovered the property and whether the property is still saleable or not. But they can then sue for civil damages of 10 times the retail price, no less than 50, and not more than 200. So there's a few other issues here. And I'm not going to get into this because it's actually a very lengthy statute. It actually is 2 pages in length, and that's single-spaced. But it also talks about the liability of a parent for a shoplifting child. That's another issue. And then it does talk about the demand letters and what the demand letters can look like. And they've actually got a form demand letter here for you. So it says here, the merchant who is the victim of retail fraud in the first, second, or third degree, or an agent of the merchant, may make a written demand for payment of the amount for which the person who committed the act is liable under the section above. And then it says, they shall evaluate the validity of the accusation, and then a member of management shall approve the accusation in writing before a written demand for payment is issued. The demand for payment may be delivered to the person from whom payment is demanded by first-class mail. And then it says the text of the written demand shall be as follows, and word for word. Quote, we have cause to believe that on date, you or your minor child's name, committed retail fraud in the first, second, or third degree by description of action and property involved in our store or in its immediate vicinity. State law authorizes us to demand in writing that you do all of the following as applicable. 1, return the property in saleable condition or pay us X. 2, pay to us X, which represents the full retail price of the recovered property that is not in saleable condition. 3, pay to us civil damages in an amount equal to 10 times the retail price of the property involved, but not less than $50 nor more than $200, equaling a total amount of X. And then it goes on to say this is noticed as a formal demand for the return of property. You are not required to respond to the demand, et cetera, et cetera. But the law is there. And this is a fairly common law in different states. Common in the sense that many states have got such a law. So what appears to have happened, again, just to be clear here, because the headline I think is a little misleading, is that they had accused her of shoplifting. And then charges were dropped against her. So she thought, okay. And then she starts getting these letters from Walmart. And under Alabama law, similarly to Michigan law, similarly to the law in many other states, they can do that if they have reason to believe that she did that and that they are the victims of it. The question then becomes, how good is their accusation and their belief? They can't just pick people at random and say, let's send that person a letter. Let's send that person a letter. Obviously, they've got to have a basis for their belief. And the question becomes, how good is the basis for their belief, and so on. And so a jury must have looked at this case and said, you know what it looks like they're doing here? It looks like they're sending letters to people who don't owe the money. And one of the things that's missing from the story is what the actual underlying cause of action was. Because some states have got laws against improper debt collection. That is, somebody comes to you and says, you owe me money, pay us. Or you owe this other person money and I'm collecting the debt on their behalf for them. If you don't owe that money, then there are laws that govern the relationship and how the debt collector has to behave. And so this may have been under a debt collection type of statute, except that I guess the letters coming from Walmart saying you owe us money probably wouldn't qualify as debt collection in that sense, because Walmart would be collecting its own debt. Of course, the question is, did they have their own people doing it, or were they having an outside firm do it? But it does say they got the money from Walmart. So, again, I don't know what the cause of action was, but what appears to have happened is the accusation was made, charges were dropped, but the letters started coming. And one of the reasons for the big payout appears to be that experts came in and said, yeah, Walmart does a lot of this. And by a lot of this, we mean sending letters to people who weren't ever charged, charges were never pressed, charges were never prosecuted fully, and it might just be that they're doing this to make money because they can send letters and get money. Because a lot of people, when faced with a letter from Walmart that says pay us $200 or bad things are going to happen, a lot of people pay $200. And that might be the friction point, where a little bit more than that, people might stand up for $200. Some people might just roll over and throw the money. So there you go. So Mark sent this to me. Thanks a lot, Mark, From WKRG out of Mobile, Alabama. Woman wins $2.1 million from Walmart. It says here over a false arrest, but I think it's over the Dunning letters. There you go. Questions or comments? Put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Make a list of things that make you happy. You'll find there are more of them than you imagined.